My name's Russell Wheeler. I, among other things, study the courts, and I study the courts because they interest me. That's not the only thing I do, but that's mostly what I do at Brookings. The court has before it this term 2 partisan gerrymandering cases, one from Wisconsin and one from Maryland. Now, for most of its history, the court refused to get involved in partisan gerrymandering cases. In 2004, 5 of the justices said, we're not going to get involved in a Pennsylvania case alleging partisan gerrymandering. 5 of the justices said there's just no standard by which to judge it. 4 of them said we should stop looking for a standard because it doesn't exist. Justice Kennedy said he agreed not to get involved in this case, but he hoped the day would come when the court could identify what he called a clear and precise standard by which to evaluate partisan gerrymandering. Now, the cases before the court from Maryland and Wisconsin appear to be fairly egregious examples of partisan gerrymandering. The question is, does it become so partisan as to violate the Constitution? In Maryland, the state Democratic legislature redid a Maryland district that stretches from Washington, D.C. out to the border, which was reliably Republican, and the legislature moved around 700,000 voters to produce a Democratic district and the defeat of the Republican incumbent in 2012. The Wisconsin case involved the entire General Assembly, the lower house of the Wisconsin legislature, under a map drawn by the Republican legislature in 2011. In subsequent elections, the General Assembly was about 2/3 Republican members, 1/3 Democratic members, even though the aggregate votes cast for all the candidates was roughly 50-50, Republican and Democrat. At oral argument in October, Justice Breyer offered what he thought was a workable standard, but there was a lot of disagreement. The Chief Justice said, if we overthrow this Wisconsin map, we'll be inviting a flood of partisan gerrymandering litigation that we'll have a hard time deciding. And to boot, said the Chief Justice, respect for the court may decline because we'll have to cite a lot of complicated statistical arguments, and most citizens will say, in Justice Roberts' words, that's a bunch of baloney, and assume it's just a smokescreen for the court's preference for one political party over the other. Now, while all these cases are moving through the Supreme Court, a sideshow was developing in Pennsylvania, one of potentially great consequence. There, in early February, Justice Alito, who hears emergency appeals from the Third Judicial Circuit, including Pennsylvania, refused to overturn an order of the Pennsylvania Supreme Court. Why? He didn't say, but it's pretty clear because the Pennsylvania Supreme Court based its decision entirely on the Pennsylvania state constitution, into which the U.S. Supreme Court typically does not get involved. At issue in this case were the 18 U.S. House of Representative districts in Pennsylvania, which are 13 are held by Republicans, 5 by Democrats, even though, as in Wisconsin, the aggregate votes for candidates for the House of Representatives was roughly 50-50. So the Pennsylvania Supreme Court directed the legislature to redraw the map and said if the legislature and the Democratic governor can't agree, the Supreme Court itself will draw the map, which it did in mid-February. That map, experts say, if it goes into effect, and the court said it should go into effect for the 2018 elections, could change a 13-5 Republican to Democratic imbalance in the legislative delegation, perhaps to 9-9. Those 5 additional seats could make a difference in the struggle for control of a majority of the House of Representatives, which is up for grabs in the November 2018 elections. Now, we don't have the decisions in either of these cases. The Wisconsin case was argued in early October. The court will take up the Maryland case in late March. But we can speculate. If the court adheres to its position that there simply aren't discernible standards by which to evaluate claims of partisan gerrymandering, most likely that will encourage the state legislatures, most of which are controlled by Republicans, but Democratic-controlled legislatures as well, to up the ante even more and engage in more egregious partisan gerrymandering to basically ignore the votes of substantial members of the population of the state, a real loss for democracy. If, on the other hand, the court has a eureka moment and says, oh, yes, there is a standard, we finally discovered one, and on that basis we're dismissing the Wisconsin map, you can be sure, as the Chief Justice said, that the court will see a flood of partisan gerrymandering claims. It is conceivable the court might try to thread the needle, refer to partisan gerrymandering as distasteful, as one of the justices said, but say we're going to get involved in those cases under a standard we will announce only in extreme circumstances. And perhaps Wisconsin represents one of those extreme circumstances, so we might throw out the Wisconsin map, order it be withdrawn, but warn litigators in the states not to bring us every run-of-the-mill partisan gerrymandering case because we simply don't have the standards by which to judge them. We'll know the answer to all these questions come June, when the court typically ends the term that begins the preceding October.